the matter of Manolete Partners PLC and Dalal and others.
Yes.
Lords, I appear for the Appellant Manolete Partners, Moylan friend Mr. Leaper, leading. Ms. Fisher appears for the respondent, Mr. Dalal. This is an appeal brought with the permission of my Lord Justice Arnold against the decision made by handed down of Mr. Stephen Jourdan QC. You will have seen that in his judgment, the judge conducted a thorough and detailed analysis of the component elements of the calculation of the company's likely trading receipts over its life covering a 10-year period, which led him to the conclusion that on that analysis there were, on the face of it, unaccounted for sales in excess of £3 million, which was, on his calculation, 12.2% of the company's total turnover. That, of course, is a significant sum. Despite that analysis, that he held that the claimant had not made out its case on a balance of probabilities, and that he didn't have sufficient enough confidence in the figures.
Do we see him using the expression likely trading receipts? Or is that your interpretation?
That's my interpretation. Right. It's not an expression that he uses, but that was his calculation. What he was doing, of course, was comparing the recorded trading receipts as recorded in the company's annual accounts over the 10-year period, which recorded the turnover. And then he was conducting an analysis to calculate or estimate what its actual trading receipts would have been from the sales of chickens slaughtered and sold as either whole chickens or cut up parts. And that was the exercise that he was undertaking. And we say that the judge fell into a number of fundamental errors that led him to conclude that the claimant had not made out its case. The starting point of his errors was his failure to follow through his own starting point of the conclusion, if I can put it that way, which he expressed at paragraph 117 of the judgment. This is page 65 of the core bundle.
Well, he first does analysis in respect to 2009.
He first does the analysis in respect to 2009.
And comes to the conclusion there is no excess receipts or profits.
That's right.
Yes.
And then you will have seen he conducts the same analysis in relation to the entire trading life of the company. That's Appendix 2 of the judgment.
Yes.
And he's conducting the same analysis in which he's breaking down the component parts to work out what, or to estimate what would be the likely sales, adopting those component parts. At paragraph 117 of the judgment, you'll see that what he says was the evidence on a number of aspects was extremely thin. He says there's substantial uncertainty about a number of aspects of the calculation. Consider where the evidence is so thin that I should simply determine it's insufficient to make any rational decision, in which case he would have concluded the claimant had failed to prove his case. But then he says, I've decided there's just enough information to make a rough estimate of the likely level of sales for that trading year. So there's enough information for him to make a calculation and to come to a rational decision on the basis of the material in front of him. Now, his observation there is limited to his calculation in respect of 2009, but it is the same process that he undertakes in relation to the entirety of the company's trading life. And
so do you think we have to apply what he says in 117 to both aspects of his analysis?
Yes, I do.
Right.
Because the key question here in this case is, does he have enough evidence before him in order to make a rational conclusion as to whether or not there was an under-declaration of sales or a misappropriation of sales. Now, when one looks at the detailed analysis that he's undertaken, one can see that, save in one respect, and that's in relation to sale prices, he expresses himself throughout in terms that the evidence before him is reliable, or he accepts the defendant's own explanations. And that's not something that we challenge on this appeal. And there are various component parts of the calculation. The first is, what is the volume of chickens that were supplied to the company? Second, what was the weight of the chickens? Thirdly, what is the amount of wastage in the slaughtering process and the cutting up process? Fourthly, what is the amount of wastage in relation to dead and ill birds? Fifthly, what is the level of bad debts? And sixthly, what are the average or applicable sale prices? Now, save in relation to the last of those, as I indicate, the judge expresses himself that the evidence before him is reliable, or he has accepted the defendant's explanation. The first of those elements, or the first two of those elements, volume and weight, derives from the inspections carried out, or principally derives from the inspections carried out by the Food Standards Agency. And they have representatives on the company's site recording the volume of chickens that are being slaughtered. You'll see that his discussion of that issue starts at paragraph 118 and goes through to paragraph 145. And there are two linked points. One is the volume of the chickens, the other is their weight. You'll see that he says at 118, HMRC and the claimant relied on information provided by the FSA, the Food Standards Agency, summarising the number of birds delivered. And then at 119, he records that most of their summaries record the chickens as having a weight of less than 2 kilograms. Mr. Collier, who gave evidence, who's the head of their revenue collection, says that he wasn't personally involved in the way in which these figures were prepared. He goes down at 122 to say the defendant's pleaded case, that these figures were the number of birds the company had hoped to slaughter, not the actual number slaughtered. And the numbers provided to the FSA were inflated so that the company was approved to slaughter up to, but not above those numbers. Then he says at 123, I accept that Sajid, that's the second defendant, believed this to be the case. It's clear from Mr. Collins' evidence that this is not how the figures supplied by the FSA had been complied. Then he says at 124, the total number of birds recorded by the FSA having been slaughtered was 30 million odd pounds. Then he says at 125, before considering the reliability of the FSA records, one needs to consider the issue of weight. Now, the issue of weight has a certain amount of complexity to it. And the reason is this. The FSA records recorded substantially that the chickens were of up to or less than 2 kilograms. There was, however, some evidence before the court of chickens having a weight of greater than that. And he summarises that at paragraph 127. there was some evidence from DEFRA of average weights of chickens being slaughtered of on average 2.2 kilograms. Specific chickens that were analysed by the AMS, these were the accountants instructed by the company, had a higher weight, and there was evidence of some specific invoices from one of the company's suppliers showing a further weight, a further sum in excess of that, of some of them being over 3 kilograms. And the judge was then required to assess whether or not the FSA records could be relied upon, firstly for the purposes of volumes of chickens, and secondly for the purposes of their weight. And he concludes that the evidence from the FSA is reliable, it can be relied on for both purposes, and it would be inconsistent to attribute some weights other than those that were recorded by the FSA. So one sees at 133, in my view on the evidence, the only reliable basis for carrying out the calculation is that adopted by HMRC, and to assume that FSA numbers were accurate and that the average weight of a live bird other than hens and baby birds was 2 kilograms. So there was another category of birds that were hens, baby birds, that were obviously lighter. It was submitted by my learned friend Miss Fisher in relation to the hens and baby birds, that reduced the average weight of the birds beneath 2 kilograms. And the judge concludes at 145, I do not think there is sufficient evidence to make an arithmetic adjustment of that kind. The average weight of 2 kilograms per bird is itself no more than a rough and ready figure, and the fact that some birds would have weighed much less is likely to be offset by the fact that some would have weighed much more. Accordingly, I've made no adjustments to the figures. So the judge is proceeding on the basis that it is reliable that the average weight of the birds was 2 kilograms.
Is that quite fair? He's saying his best bet is that they're 2 kilograms. The FSA records on which he's relying show that overwhelmingly the weight, well, actually it's less than 2 kilograms on the FSA figures, isn't it? Because it isn't less than or equal to, it's less than. So, okay, best bet is that the average weight is 2 kilograms. But there must be at least a significant, probably a substantial possibility that the average weight is 1.9 kilograms or 1.8 kilograms. Is that fair?
Yes, it could be less than 2 kilograms. I accept that it is fair. I accept that the FSA records don't identify within that whether it's 2 kilograms or not. But the judge conducts his analysis on the basis that we'll take 2 kilograms as the appropriate starting point, accepting that there is a fair amount of evidence that actually the average weight of the birds is more than 2 kilograms, and there is some evidence that there were some birds that were less than 2 kilograms.
And I quite followed that. But if you got a statistician onto this, presumably the statistician would say, well, 2 kilograms is your best figure, but a figure below that is also a very real possibility. It
is a possibility. So the question for today is, does the judge come to the conclusion that the 2 kilogram figure is a reliable one for the purposes of reaching a rational decision? And I say at 137, 133 and 137, he's concluded that these are reliable figures and they're reliable for the purposes of his calculation. It would have been open to him to have said, well, these figures are just too unreliable, they're too uncertain, there's too much that I can't tell from these figures, So I can't make a rational
I
decision.
appreciate that, and that's what he's dealt with in 117, saying, but he is he saying, I mean, you was the word reliable, but I'm just testing that by looking at what the exercise is that the judge is undertaking in these paragraphs. Because going back to 117, he uses the expression, enough information for me to make a very rough estimate of the likely level of sales. And in 133, which you've taken to, the only reliable basis for carrying out the calculation, not to make a calculation, and to assume that the figures were accurate. So he's carrying out a rough estimate calculation.
Yes, he is carrying out a rough estimate calculation, and he does it indeed express it in terms that it was somewhat rough and ready, because it is for obvious reasons, it is incomplete. There's evidence that points a number of ways. The evidence that is summarised at paragraph 127, for example, indicating a fair amount of evidence, put it that way, of birds having a weight beyond 2 kilograms. So he fastens on the 2 kilogram figure and says at 133, well, the only reliable basis for carrying out the calculation is to assume that they're accurate. He's not saying, well, this is just too unreliable to be reliable. Yes, the evidence is not complete, and yes, it points in some different directions. The only evidence that there actually is that tends to alter the 2 kilogram figure, or 2 kilogram weight, are those factors at 127, which go to enhance it rather than reduce it.
The AMS report is the report by the accountants who were brought in by the company to challenge HMRC's calculation. And the challenge produced a figure of 2.61 kilograms per bird.
That's right.
Can you help us, how many, it says a number of purchase invoices between December 2005, June 2012, so that's a reasonable chronological range. How many invoices was that based on?
That's actually quite a considerable number. It is in the AMS report. In the supplemental bundle, it's page 95. What HMRC did when they were sent this report is they then extrapolated from those invoices the average weight.
Sorry, when you say page, is it what, the AMS, the figures being referred to in whatever the paragraph it is, and I lost it, are 95 and 96?
Yes.
The AMS, so December 2005 to June 2012, is this, I can't actually see, my eyesight isn't up to it.
So
numbers? Or?
What they have had is they have seen some purchase invoices, a rather large number of them, spanning the period 2005 to 2012.
I see.
They've recorded number of chickens purchased. I'm just looking at the first line. Records the number of chickens purchased in that invoice, the weight of the chicken, the cost, cost per chicken, and so forth.
So what is that? About 70?
What?
It's
so sorry.
about 70. I mean, I just
Yes, that's about 70. Yes. What HMRC did when they received that report, amongst other things, was to analyse out that table at page 95 and 96. One can see that at page 470 and 471. And what they've done is they've simply put those figures into a spreadsheet in which they've identified the numbers of chickens purchased, the weight, and then averaged out the weight, then applied a 25% discount, which at that stage was looking at what the wastage element would be. But for present purposes, if one goes over the page to 471,
so that's the 2.61.
That's where the 2.61
I see. And that's all the invoices from pages 95 and 96.
Yes, it is.
And I mean, on the face of it, that then produces a mismatch between that calculation and the FSA records, nearly all of which it says shows the birds weighing less than 2 kilograms. How do you reconcile the two?
I submitted to the judge, which he didn't accept, I submitted to the judge that where there was evidence of birds weighing more than 2 kilograms, that should be taken into account. And that a calculation in relation to the balance could proceed on the basis of what was in the FSA records. He didn't accept that analysis. He said, well, if we're adopting the FSA analysis in relation to the volume, then effectively, for consistency purposes, we need to adopt it in relation to weight.
So, on your thesis, what was the idea that in relation to these 70-odd transactions, those you took these weights, but the rest you assumed the FSA was right?
Yes, simply on the basis that this amounted to better evidence. So one has to accept that there is a level of uncertainty as to how complete the FSA records were in relation to weight. And my submission in relation to that is that when the judge then conducts his exercise, he conducts it on the basis that the 2 kilogram figure, whilst rough and ready, is a good enough starting point from which to make a rational decision, and that it is a reliable figure for the purposes of carrying out a calculation.
Bearing in mind, as he says repeatedly, that it's an average.
Bearing in mind that it is an average. So that is what the judge found in relation to volumes and in relation to weights. The next issue that we had to consider was what is the proportion of chickens that are lost in terms of wastage. That involved a number of elements. It involved, firstly, the question of if a chicken was slaughtered and sold whole, how much of the weight would be lost in terms of the head, the beak, and so on and so forth. And then a separate exercise that if the chicken was then cut up into parts, there'd be a further element of wastage. I can probably cut through quite a lot of this. Paragraph 152, he sets out the first defendant's evidence on quotes from Mr. Dalal's witness statement, in which he says the meat following the process of a live bird would be approximately 60% of the weight. And that's described as the wastage. The judge then does a detailed analysis in which he analyses what the wastage of a whole bird might be and what the wastage in relation to a cut-up part of the bird. He relies in part on, again, some evidence that was in the AMS report of a brochure from a chicken processor. And you'll see that he concludes at paragraph 163, the wastage percentage deduction for chickens cut up into parts is 65% of a 75% figure, 75% figure being a 25% wastage of chickens being sold whole. And so he arrives at a percentage weight or starting point of a percentage wastage of 50%. Then over the page, 165 to 168, he records that, and this is particularly at 166, that the learned friend Miss Fisher had conducted an analysis of 182 invoices that were in the trial bundle. And that had established that 42% by weight of the chickens were sold as whole birds, and the remaining 58% were cut up into parts. When the wastage elements were applied to the sales of whole birds and sales of parts, one gets to an overall wastage deduction of 42%. One sees that at 168C. And he says that compares reasonably to Ebrahim's, the first defendant's estimate in his witness statement. The total wastage was around 40%. On the evidence, that's the best estimate I can make of wastage. So what he has done there is he's firstly seen what the first defendant said. He's conducted a separate analysis based on the evidence of what was in the Ross Broilers report and the analysis of the breakdown of the 182 invoices that were before the court, and arrived at a figure that is effectively the same as what the first defendant said.
Well, not only that, it is premised on the submission that was actually advanced in the written submissions recorded at 167 as to the proportion of whole birds being as low as 33% and the cut parts being as high as 67%.
Yes. So he's accepted the
So it's that's the defendant's own case being accepted there.
Yes. Yes. He's accepted the defendant's case, and he's made the calculation on the basis of accepting the defendant's case. We make no, we don't challenge that, we accept that. So in relation to that element too, he's accepted the defendant's evidence.
What do you say about the use of his word estimate?
Well, one has to accept that the whole exercise is an estimate. There aren't complete records. So the task, the fundamental task that the judge was having to undertake is, well, can I make an estimate that has some reliability to it? And that comes down to comes back to what I say is there's a fundamental question, which is, well, is there enough material here for a judge to make a rational decision? So we've seen that he's accepted the defendant's evidence on question of wastage. You have my submissions in relation to volume and weight. The other elements in relation to wastage concerned birds that were ill or dead. He accepts the defendant's evidence there. This is paragraph 176.
Sorry, 100 and...
176.
Thank you.
I'm sorry, 176. I'm so sorry.
176 is bad debts. Yeah.
He accepts the defendant's evidence in relation to bad debt. He also accepts the defendant's evidence in relation to dead and ill birds, where there's a 5% deduction made for.
Right, that's 142.
Yes, 142.
Yeah. Yes.
So on those elements too, he's proceeded on the basis of the defendant's evidence. The element that's...
So then bad debts is 176.
Bad debts is 176.
Yeah. Thank you.
The element where there is uncertainty concerns the average selling price. Now, the starting point was that when HMRC had prepared its business economics exercise, it adopted two methodologies. One of which it looked at a small number of invoices, looked at the individual sale prices at which the various parts or whole chickens were being sold for, and applied that against a figure of £2.75 per kilo, which was effectively HMRC's own anecdotal evidence. We didn't place reliance on that at the trial. The second approach was the more analytical approach, if I can call it that, which was looking at the average sale prices of recorded in those particular invoices. If one looks at the judgment at paragraph 169, the judge records, we disclaim reliance on the first of the methods. In relation to the second of the methods, Ms. Fisher had rightly pointed out that there were a number of arithmetic errors. HMRC had come out with a figure of £2.62 and she said, well, actually it's really only £2.48. And then there were the 182 further invoices in 2011, 2012. These didn't form part of HMRC's analysis, which was only looking at 2009. You'll see at 173, he records that the invoices in the trial bundle, which he analysed, consistently recorded a selling price of whole chickens of £1.75, and in relation to parts, an average price of £2.37. That was an analysis over 182 invoices covering a 2-year period.
Yes, so am I right in understanding that's August 2011 to August 2013?
That's right.
And so the defendant's own analysis at trial was that over that 2-year period there was a consistent price of whole chickens at 1.75 per kilo, and on the parts the average over that 2-year period on the defendant's analysis was 2.37 per kilo.
That's right. And what there was any case advanced by the defendants at any point of time that said, actually, those prices, as recorded, whether in the 5 invoices that HMRC relied upon, or in the 182 invoices that were in the trial bundle, it was never said by the defendants, well, actually, these are higher than average. they are unreliable as a sample. One of the things that is notable.
But just to understand that, we see in paragraph 170 that Ms. Fisher submitted that the sample used was too small to give any reliable indication.
That's the 5 invoices.
That's the 5 invoices. Yeah, I see.
Fine.
Yes, I see.
And the judge agrees with her. He said, well, actually, if we were just relying on the 5, I'd
Yeah.
too small. I made the point, or moving on to the point, that at no stage did the defendants ever say, either in relation to the 5 invoices or in relation to the 182, these are unrepresentative. These are atypical. They're not an accurate or an appropriate sample.
Maybe they didn't, but the judge says they're not a very reliable guide.
So the question then one has to ask is, well, why are they not a very reliable guide?
But that's his finding.
That's his finding, and the question is that a finding that he's able to reach on the basis of the material before him? One might be able to say, well, it's not a very reliable guide because there was some evidence that pointed the other way. So if, for example, the defendants had said, well, this isn't a very reliable guide, we think that these prices were that are relied on in the invoices, 187, were above average and don't represent the company's selling prices, then that would be something the judge would have to start addressing as to whether or not it was a reliable guide.
So you said he was said it was only 3.7 of the reported turnover. So that meant that they weren't, well, that's what I take from that sentence, a very reliable guide. Do you say that's, what, an impermissible conclusion?
I say that, firstly, any sample is, of course, going to discuss that, and it might be a small sample, but if you are going to conclude that it is unreliable, then you have to have, there has to be some evidential basis.
But he doesn't conclude that it's unreliable. He says not a very reliable guide, but it's the best evidence available. And your point is that he then goes on to adopt the figures produced by Ms. Fisher's analysis. So he's first of all said it's the best evidence available. Secondly, he's adopted those figures.
That's absolutely right. Yes, he has. Yes, he has.
So he's made a finding
Yes.
as to what the prices were.
Yeah, well, I think that's exactly right. And he doesn't set out any basis for concluding that it's unreliable. So if, for example, firstly the defendant had said that it had been unreliable, or if there was some question mark as to the authenticity of the invoices, there was a question mark about them in some way, or there was some evidence that said, well, actually, these might have been the sums in the invoices, but there were substantial returns, or there was some other basis to indicate that they were intrinsically unreliable to form a proper data set. Those are the questions, in my submission, the judge ought to have been asking in order to address the question of whether or not this was reliable. What the judge has done is he said, well, it's a small element, it's a small sample, and therefore that's not enough. And he's gone no further. In my submission, he needed to have gone further.
Well, he doesn't say it's not enough, because if it was not enough, he would have made no finding. He says it's not very reliable, but it's best evidence, and then he does make a finding.
Yes, he does. And I say what logically follows from that is the conclusions that he comes to on the figures in Appendix 2. Namely that these figures can be relied upon. They can be relied upon to make the calculation that he makes.
Can I explore this a moment? If we go to the judge's Appendix 2, page 86, I think, of the bundle. We see he his various calculations, and as regards the price per kilogram of cut parts, £2.37, which will obviously account for a smaller proportion of the total sales figure. Going back to paragraph 174, we see that that's an average.
Yes.
If it's an average, then presumably it could be higher, it could be lower, if you took the complete set of sales figures.
Yeah, I mean, it's an average. Yes.
So perhaps the more important figure for your case is of £1.75, because that accounts for a larger proportion, does it, of the total sales? Or maybe not. Maybe
No,
I'm misunderstanding.
No, because 2/3 of the birds were sold in parts, excepting the defendant's case.
So sorry. So actually, I'm wrong. It's the £2.37 figure that matters more.
Yes, I think it does.
And a statistician presumably presented with, I don't know how many of these invoices included prices for birds sold in parts. But it won't perhaps be all of them. I don't know. And then you have to extrapolate over a 10-year period. In the 2-year period, there's presumably some variance between the prices, otherwise you wouldn't get an average. So would not a statistician say, well, the best bet might be £2.37, but there's a, 40% chance of it being 20% less than that?
The difficulty with that is, of course, as an average, what's happened is the entire data set has been looked at. Some of those prices will have been greater than £2.37, some of them will have been less. Their sales of different chicken parts, which of course sell for different prices.
So breast is sells for more than thigh.
Absolutely. And
wings even less.
So it's an amalgamation. It's inevitably an amalgamation of different chicken parts. By definition, in the notion of an average, given that there is a fluctuation of the prices, there will be some higher and there will be some lower.
But pursuing my lord's question, would I be right in guessing that although the mean was calculated, nobody calculated the standard deviation?
That is right.
Yeah.
That is right. It is, I mean, in a sense, it's probably more accurately described as a mean weight rather than a mean price.
Yeah, well, it's obviously not the median. We can tell that. No, it's a mean, but there's no calculation of standard deviation.
No.
Yeah.
And just, I think, to show that I can't get anything from this, if I go in the supplemental bundle to page 218, this and the next few pages are Miss Fisher's analysis of all the invoices, presumably.
Yes, that's right.
At this stage, in the average price per kilogram column, you get all sorts of figures. That's because it's an amalgamation of whole chickens and parts.
Yeah.
And if one looked beyond this summary to the actual invoices, you would at that point find that whole chickens was 1.75 per kilo.
And the whole chickens were almost consistently 1.75 in that 2-year period.
Yes.
There was hardly any, if any, fluctuation.
Yeah.
As indicated, some parts had fluctuating or differing prices for those obvious reasons. If one returns to the judge's conclusion, starting at paragraph 181, starts out by addressing at 181's figure his calculation for 2009. And then says at 182, I have very little confidence in the accuracy of that figure for the reasons that will be evident from the discussion above. That's the best I can do on the evidence called at trial. Now, for the reasons I've indicated, he's actually said, well, these figures are reliable for evidential, to which I add in brackets for evidential purposes, or he's accepted the defendant's evidence. And then at 183,
Sorry, does he ever anywhere use the word reliable?
does he use the word reliable?
Yes.
Yes, he does. In those passages at 133, 137, which I took you to.
The only reliable basis for carrying out the calculation. He doesn't say the figures are reliable. It's a reliable basis for the purposes of his exercise.
Yes.
Is that dancing on pins, or is that a substantive difference?
I don't. My question, there isn't a substantive difference.
Okay.
Because what he appears to be concluding
Okay, I understand.
at 183 is actually these figures aren't reliable for purposes for evidential purposes. There's too much uncertainty.
So just pausing at 181, 182. It's your case, is it, that the calculations you get there are wrong? Because there was, in fact, a diversion of income in that year, even though it's not shown up in the calculation.
No, I accept that his calculation. I accept his calculation for 2009. I don't challenge his calculation for 2009.
So there was no diversion in
There
2009.
on those figures, there isn't a diversion for 2009. I have to accept that. Because what he's done in his Appendix 1, his 2009 calculation, he's adopted the same methodology as he does for the entire trading period in Appendix 2. And he's adopting that calculation. He's ended up by saying the estimated sales were 2.616 million as opposed to those reported in the sales of being slightly greater. So I accept that for 2009, for that 1 year, it doesn't show an underdeclaration.
And I've forgotten what years your claim is based on.
Well, my claim is based on the entirety of 2005 to 2015. I say that there's nothing that flows. There's no consequence from the fact that in the sampled year that HMRC were relying on, the judge has come to a different conclusion, that there wasn't an underreporting. I say nothing flows from that because the purpose of this case is to look at what happened overall over the entirety of the company's trading life. And whilst the case, whilst the HMRC exercise was the starting point, that's not what the case is fundamentally about. But also, that deals with what I describe as his sort of error of principle or error of logic. There's then a question of whether what he was doing was effectively engaging in inquisitorial exercise rather than determining the issues as between the parties on their pleadings. And in my submission, what the judge actually was doing was going beyond the bounds of what is permissible for a judge to do by determining the issues as pleaded between the parties and as spelled out in the parties' own cases in their evidence and submissions. The defendant's case can be seen from his pleading. 108. And what's paragraph 11? It's paragraphs 11 and 12. What the defendant is addressing are the assessments that have been relied upon by HMRC, which form the starting point, which are based on the business economics exercise. And he says it in 11, the accuracy of the assessments is denied. In particular, HMRC employed underlying methods, estimations and assumptions fundamentally flawed. And then one has a failed to take account of wastage. And that has the two elements. One, no allowance for wastage in terms of feathers, offal, bones, etc. And failed to give any allowance for ill birds, birds unfit for consumption and so forth. And then at B, the figures used by HMRC were flawed in that their figures were based on a retail model, didn't take account that the company was a wholesale supplier. And then the other objection that was made, this is over the page, B2, HMRC's approach in obtaining records from the FSA failed to recognise the figures held by the FSA merely identified the number of birds the company hoped to slaughter, not the actual numbers slaughtered. Numbers were inflated. And then at 12, it says no reference made in particular claim to the contents of the AMS report, where it said they conducted an in-depth analysis to assess the correct level of sales, investigated the correct level of turnover by sampling quarterly sales, and concluded the turnover had been understated by a relatively modest amount. Just leaving paragraph 12 to one side for the moment, in paragraph 11, what's notable is there's no challenge at all to the use of the prices that HMRC have identified from their analysis of the invoices.
And just to be clear, this point the defendants are answering your paragraphs 10 to 12, which are pages 92 to 93.
Yes, that's right.
And there you say, well, we've assessed, or HMRC assessed, and in 12 you say, in summary, there's Food Standards Agency, their records, you extrapolated from 2009, then there's AMS. So first of all, what prices are you putting forward there?
So, if one goes back to the particulars of the page, paragraph 10 and 11, so 11, the basis of the assessments which were raised following an investigation by HMRC into the company's affairs is set out in documents produced by HMRC, copies of which have been provided to the defendants. That is a reference to the business economic exercise. And that set out various prices. If one turns in the supplemental bundle to page 73, that summarised the prices that HMRC had found. Additionally, in the supplemental bundle at page 473.
Yes, just before you move on, can you help me on this? Where do we find method 1 and method 2 here?
Page 75 is headed second method, where there isn't a heading that says first method. But at page 73...
Sorry, I seem to be missing page 75. My supplemental bundle skips from 73 to 76.
I'll pass up. Page 75. Is it just that page, my lord, just 75?
No, I'm missing 74, 7 and 75. Sorry, you were explaining.
At page 73, you'll see 3/4 of the way down, price of chicken meat. And it says HMRC third-party sources show that 15 kilograms of chicken meat was selling for £2.75 per kilo.
I see, right, so that's method one.
And that found its way through page 74, about a third of the way down. That 275 figure is applied, and that's where HMRC gets to.
Right.
That
And
figure.
at page 75, we have method two with the figure from the 43 invoices.
Absolutely.
Yeah, thank you.
And to be fair, not to mislead, it's actually 43 items in 5 invoices.
Yes, I apologise, yes. It's said to be 43 invoices
It is
on
said
the
to be
page,
43, but it's, yes,
but that's
does say
not,
that,
that's wrong,
but,
yeah.
So that is, those are the calculations or the prices that are relied on. The backup document to that.
So just pausing there. So in your pleading, you say we've supplied you with documents which show the basis of the assessments. So just looking at your summary in 12, you've got the figures from the FSA. 12.3, you extrapolated from the slaughter figures and decided that there'd been sales of £35 million additional to the sales shown in the company's accounts. Then you say, well, AMS said 20% and that the assessments are based on 20%. You've accepted 20%, but what sales price is inherent in the 20% acceptance that's followed through in the assessments?
There aren't any. It's not a reference to the sale prices. What HMRCs have done is say, well, we calculated it at £35 million. UAMS are prepared to concede that the true figure is about 20% of that. So we'll raise assessments for that sum. That's what HMRC did.
And so you're not then following through on your business economics exercise, which would have suggested a much higher figure.
To that extent, no. There's a concession involved in all of that. That's right.
And in the end, obviously, you found your case as presented to the judge, not merely on these materials, but on all sorts of other materials.
Yes.
And you were entitled to do that consistently with your pleadings. And why couldn't the defendants themselves say, well, we're relying on these other things too, especially since in paragraph 13 of the defence, they deny paragraph 13 of the particulars of claim. And they say the additional sales receipts present an inaccurate representation.
I think one has to separate out paragraphs 11 and 12. 12 is based on the AMS analysis. And had there been permission for AMS to give expert evidence, or had Mr. Clegg, who was the author of that report, given evidence, then I accept that the question of sale prices would have been a live issue to have been determined. and it would have been a live pleaded issue at the trial. I accept that. But neither of those things happened. There was no report served by AMS in the proceedings. There was no application for permission to serve experts' report. Mr. Clegg didn't give any factual evidence of the exercise he'd done. So the judge rightly accepted that reliance couldn't be placed on the AMS. For the purposes of then addressing the question, well, what are the issues before the judge at the trial? The question of prices, which for pleading purposes had some reference in paragraph 12, is not before the court because there's nothing to support it.
So what plea as to price do you say that the defendants could not contest?
What plea as to price could they not contest?
Yes.
As at that falls into two parts, I think. As a matter of strict pleading, they could not contest the HMRC prices in the 5 invoices because they haven't challenged them. They haven't said they're wrong.
But presumably nobody contested the prices in those invoices.
Nobody contested.
What they would want to contest is the extrapolation across
Yes,
10 years.
Absolutely. That expresses it.
You say that they could not contest that the prices given in your business economics exercise were representative across the 10 years.
They couldn't do that because they hadn't identified that was an issue that they were challenging.
Even though,
in the HMRC,
in reality, your assessments don't reflect business economics exercise.
well, they do say that there's been a concession in relation to the assessments that have been served.
Well, presumably your best estimate is that the figure was 20% of what you had calculated.
Well, nominal. I mean, we've acknowledged that was HMRC's approach to it. And it's right to say that in the relief that we saw, we limited the claim to the same amount that HMRC had assessed. We acknowledge that. And so that's a limitation of a monetary limitation in the claim. But in terms of the issues that were before the court for it to decide, I say the question of prices isn't one of them. And I'm further supporting...
So you mean evidence on prices was inadmissible because it wasn't an issue? So all the evidence the judge heard about price should not have been admitted?
No, that's not my submission. My submission is it wasn't open to the judge to go behind the average prices that were shown to him, analysed out by the Defendants Counsel.
Sorry,
It wasn't open to him to go behind that because the defendant weren't making any challenge to it.
sorry, can you say it wasn't open to the judge to go behind the average prices shown to him by...
A, by the business economic exercise, and B, by the exercise in relation to the 182 invoices in 2011, 2012.
So that's not a pleading point. Is that a pleading point or a...
So the first point is a pleading point. The second point is, well, what is the defendant's case as it appears at trial?
Sorry, it's me. I'm really not following this at all. First of all, in paragraph 11 of the defence, the accuracy of the assessments is denied.
Yes.
So the entire accuracy of the assessments is denied.
Yes, in general terms. Yes,
But if you deny something, you deny it, and then the burden falls on the person who is seeking to prove it. Then you take us to the business economics exercise, which deals only with 2009. And the judge actually found there was no excess sales in 2009. So it wasn't open to him to make that finding because of what?
In relation to 2009,
Yes.
I don't challenge his findings.
Right. So So 2000. So is there any other evidence about any other year in terms of business economics exercise?
In terms of the revenues exercise, no, there isn't. No, there isn't in relation to the revenues exercise.
And that's what you're relying on.
Perhaps I can deal with it in this way. In our reply, there are two documents I want to take you to. The first is in our reply. We had identified that the case wasn't, as far as we were concerned, just limited to the business economics exercise. Supplemental bundle, page 4. Paragraph 5.
Hold on. Page 4, paragraph 5. Yep.
That set out that the liquidator of the company had calculated the total sales of slaughtered chickens on those assumptions.
Yes.
Would have produced total sales of 57 million pounds.
So you're enlarging the evidential basis of your case.
Yes, that is enlarging the evidential basis of our case. Yes, I accept that. When it then came to the...
Sorry, I still don't quite... You're saying the judge wasn't entitled to go behind the average price shown to him by the business exercise of 182 invoices. But this does. This is 275 per kilogram, so it's a different evidential. So...
Well, 275 is method 1, as I understand it.
275 is method 1. When the liquidator then gave evidence in his witness statement, he produced calculations showing at 275 and at 262. 262 was the basis that appeared in the business economics exercise as the average.
Yes, but your submission is that the judge was bound, in a sense, either to accept the figure in the business economics exercise or to accept the figure in the 182 shown by the 182 invoices. And a judge couldn't go behind that evidence.
Provided that there was a fundamental basis of reliability. So if those invoices were in themselves fundamentally unreliable in some way or another, then I accept that he couldn't rely on them. But if there was nothing about those invoices that would suggest that they were unrepresented or atypical, then it wasn't open to have conducted, to have gone further than the case that was being advanced by the defendants. And my point is, that was the defendant's case. They weren't addressing the question of whether the invoices, whether it was the 5 in the BEE or the subsequent 182, were atypical or unrepresentative. That wasn't their case. And I make good that in my submission by reference to what Mr. Dalal says in his witness statement, in his trial witness statement. This is in the supplemental bundle 45-46. This, of course, is made at a time when the 182 invoices have been disclosed.
Sorry, which paragraph?
Paragraph 16.
16.
16 starts at the bottom of page 45.
Yes.
Basically, the sole point he is making in
Sorry?
his evidence
Yeah.
concerns wastage. He has the opportunity of saying, well, I don't think these invoices are reliable. I don't think that they are a representative sample, that the average is too high, or anything about prices at all. Remarkably silent about prices.
Can I ask you this question? I appreciate you're making a point presently in support of ground one, but just pursuing this line of thought, did you put the 182 invoices to Mr. Dalal in cross-examination and put it to him that they were a representative sample?
I think, to be fair, rereading the transcript, I didn't put it to him in quite those terms. No, it would be unfair if I suggested otherwise.
So the judge then is left with a vacuum so far as the evidence on that particular point is concerned, because he has no positive evidence from Mr. Dalal in his witness statement to say that 182 is unrepresentative, but equally it's not put to the witness that they are representative. So what's the judge supposed to do?
The judge has to confine himself to the case that's actually being put by, advanced by the defendant. Both in pleading and in witness statement. So, in the circumstances in which the defendant is not presenting anything that says these can't be relied on, the judge, my suspicion, is in error in concluding that they can't.
Sorry, I'm not sure I see for myself. I follow that. The judge has evidence, and he has to decide what findings he can make or what conclusions he can come to based on that evidence. That's not confined by the party's case. It's where the evidence takes him.
Well, of course, as in any case, the judge has to make findings based on the cases that are being advanced by the party. The judge can't go beyond that. The judge can't engage in an exercise himself.
So I think judges often reach conclusions on the facts which aren't in accordance with either party's case.
There's a difficulty with that, of course, in that if what the judge is doing is stepping beyond the cases as presented by the parties, then the judge is engaging in an exercise that goes beyond what a judge is supposed to.
You'll have to explain that.
Perhaps I could. The best way to deal with that point is
Judges are not bound to reach conclusions by either party's evidence. It is often the case that in all sorts of areas that a judge doesn't agree with the evidential case, or indeed the cases advanced by, if you take a simple road traffic accident, it was all his fault or it was all her fault. No, the judge finds on the basis of facts that it's 60-40 or 70-30 or 80-20.
yes.
Why is the judge going outside his obligations?
Well, in that instance, not at all, because if Party A says, well, it's all Party B's fault, and Party B says it's party A's fault, then the judge has got the issues defined in it. Whose fault was it? And the parties have identified what their case is, and the judge then proceeds and makes findings in accordance with that. What the judge isn't entitled to do is step outside of the confines of what the party's case is. And it's simply that.
Well, then it's a binary exercise. Is that what you say? If on the evidence in this case, the judge had to find one party was right or one party was wrong on the basis of wastage, couldn't go in the middle. On the basis of price, couldn't go in the middle, had to accept one party's evidence and price or the others.
No, I'm not suggesting it's binary in that sense. The judge needed to make a series of estimates, and I accept that there was a range of estimates that he could have come to, and that's what he's done. The difficulty is that is having conducted that exercise, found all sorts of evidence reliable enough, used it to make a calculation. The calculation produces a result, and he then says, well, actually, I'm not sufficiently comfortable that there's a strong enough evidential basis for that. So, having made that calculation, he says, well, actually, I'm not going to follow it through, and I'm not going to rely on it, and I'm going to conclude that the claimant hasn't made out its established burden of proof. I have some submissions on burden of proof, which I'll come to. But on this issue, no, it's not a question of, there's nothing binary about it in that sense. But insofar as concerns the question of the sale prices, what does the case look like? The case looks like the claimant is saying, these are the sale prices. The defendant actually analysed them out and says, well, this is what they show. Yes, they are a sample. And the defendant isn't anywhere saying, well, actually, the real sale prices were different. If the defendant had said that, if the defendant's case was, well, actually, the real prices were, we were selling for much less than what appears in these invoices, then that would have been a very live issue, and the judge would have had to have determined it.
Not quite sure I see this. I mean, if you had pleaded, which I don't think you did really, that the sales prices were X in your particulars of claim, and the defendants had not taken issue with that, then maybe it would have been irrelevant to look at the 182 invoices because it wasn't open to them to contest what you had pleaded. But you don't actually plead sales prices in your particulars of claim. You do say you've supplied some documents which are the basis of the assessments, but even then that's not exactly true because the assessments are for 20% of what the documents would have suggested. And in any event, come trial, there doesn't seem to have been any objection to analysis of the 182 invoices. Was there any objection to the 182 invoices being analysed? In which case, why couldn't the judge take into account what the analysis showed?
On the contrary, I'm saying he should have taken it. That's what he did, and I've got no objection to him doing so.
Which is fine, but then that's not a pleading point because you're accepting that it was open to the defendants to explore the prices. Otherwise, why look at the 182 invoices?
The point is this. Having done that exercise and said, well, look, this is what these invoices, be it the 5, the 182, this is what they show. Then it's for the defendant to then say, well, actually, even though this material, which is before the court in evidence, and we've analysed it, it's for them to say, well, actually, you, judge, shouldn't rely on this.
And I quite see, in relation to your other grounds of appeal, you have all these points about 182 invoices, but it doesn't seem to be a pleading point because you didn't plead the prices And come trial, no one objected to examination of the prices by reference to the 182 invoices, even though that would have been inconsistent with the BEE.
I have to accept it's not just a pleading. It's not just, oh, this is all inconsistent with what's in the defence. I have to accept that because the case moved on. I accept that. My submission is one has to look overall at what the defendant's case was as they were presenting it at trial. And that looks not just at the pleading, but also at the evidence that was provided, and also at the case that was being advanced in submission. And it wasn't being suggested in submissions that those invoices, the entire 187 of them, were unrepresentative. There were points being made about arithmetic errors. There were points being made about the £2.75 Model 1 not being reliable. But there was never said at any stage, well, these are just, these can't be reliable. The only point that was made was it was a small sample.
Now, isn't that a point being made?
Well, to which I say, yes, it's a small sample. To which then one needs to, and I've made this point, one then has to start addressing, if it's a small sample, what's the difficulty? The judge needs to ask, well, what's the difficulty? In what way are you saying that it is unrepresentative? Now,
And nobody asked that question.
No, that was not submitted by a learned friend. It's not clearly not addressed by the judge in his judgment. That's all I'd say on that topic. The third point in relation to which I say the judge fell into error was his approach to the burden of proof. What he said was, the company is not, the claim is not established. It's not satisfied the burden of proof. And at paragraph 186.
Sorry, you gave a previous paragraph. Was it just 186?
Well, actually, the analysis, I think, probably usefully starts at 183.
Right. Can you just, in summary, say what your submission of what he got wrong?
He had the wrong approach to the burden of proof, and the right approach would have been to ask: is there a rational basis? Is there a rational evidential basis for me to be satisfied on the calculation I have made that the claimant has satisfied the burden of proof in this case?
Sorry, say that again. Is there a rational evidential basis for me to be satisfied on the calculation I have made that the claimant has proved his case? And what do you say he in fact did?
And it's only if...
Then what did he do? That's what you said he should have done. What do you say he in fact did?
Was say there's too much of a discrepancy. The claimant has not proved it's more likely than not that there were the additional sales receipts. And he said that the margin of error in arriving at a figure of 12.2% was too small.
Now, you can't take exception, I mean, you can take exception to the substance of it, but when he says, as you say, it hasn't been proved that it's more likely than not that there were excess sales. That's an application, conventional application of the burden of proof.
Well, it's an expression of the burden. It's a formulation of the burden of proof. The question is, well, is he? Is that a conclusion that he can properly reach, or put another way, is he right in saying, well, there is insufficient evidential basis to reach the conclusions that I have? To which I say, if going back to where I started, if one looks at the component elements of his calculation, they're either reliable or they're in acceptance of the defendant's evidence. And in relation to the sales invoices, leaving aside the pleading point and so forth, in relation to the sales invoices, these are reliable documents. Yes, it is a sample. There is nothing pointing the other way.
Well, there is. Can I put it this way? The calculations produce a 12% excess, but at least two of those figures, two significant figures, are open to serious doubt because weight is rough and ready, and even if the £1.75 for whole birds is consistent, the £2.37 isn't. So there must be some possibility of the true mean, if you took the whole period and all the invoices, being lower than that. And then you put into the balance the fact that you've heard these witnesses and you think they're telling the truth. And they couldn't have been telling the truth if there was diversion. So how do you weigh in the scales on your case the fact that you think these witnesses were telling the truth, that they didn't think there was a diversion, when they surely would have thought there was a diversion if there was one?
That ultimately then comes down to a question of assessment of the evidence of those defendants, and one has to weigh that against the analytical exercise that one's undertaken.
Absolutely, you weigh the two together, and your analytical exercise may influence your conclusion on credibility. Your credibility assessment may influence your conclusion on the implications of the analytical exercise.
Yes, I accept that as a possibility. I accept that as a possibility, and there could be all sorts of, although it's a large figure over a 10-year period, there are possibilities in between. One possibility in between is they might not have thought that, but in fact they were not properly accounting for the company's receipts. I mean, one thing that's not in dispute in all of this is that the company's books and records were, to a considerable extent, let's use the expression, rather shambolic. Both sets of accountants who were involved in this case commented on how poor they were. So there is the possibility that actually there were significant under-declarations of misappropriations of the company's monies, or no proper application for the company's purposes.
Can I just ask, what was the judge's assessment of the witnesses? Because I'm looking at page 55 in the core bundle, which seems to me to be the relevant section. And in paragraph 59, the judge says that Ebrahim gave evidence via an interpreter from home, 84 years old, said his witness statement again, he was memory defective, struggled to understand many of the questions, his answers to many of them, he could not remember the relevant events. And then there's reference to Sajid being very nervous, whereas Anisha was a good witness. And then in 62, he says, as far as the evidence of the witnesses was challenged, I will evaluate it by reference to the uncontested documentary material inherent probabilities. I don't think any of the witnesses would give evidence they believe to be false, but human memories are fallible, and the evidence of a witness may be incorrect if they believe it to be accurate. So where does that leave us?
Well, so that's not a finding. That's not a finding that says, well, if the witnesses considered there was no misappropriation, then there was none. His assessment of the witnesses is well, Ebrahim much of which Ebrahim said he couldn't remember.
But what so it's my fault. I didn't really identify clearly the question I was asking, because that's the general assessment. Is there somewhere else in the judgment where the judge specifically addresses the evidence of the witnesses, in particular the first defendant, as regards misappropriation?
No.
And does he say, yes, I believed him, no, I didn't?
No. No.
Right.
His assessment is limited to those passages that you just identified. And in a sense, that perhaps addresses the point my Lord Justice Newey was making. That the judge isn't going as far as saying, well, what the defendant says must be, what the defendants have said must be true, and therefore there can't be any misappropriation. My Lords, in relation to burden of proof, the law in relation to burden is, in this respect, it's a position of last resort. It's a position of last resort in that if the judge can't decide the case on the evidence before him, then there's recourse to the burden of proof. And the test, which is where the judge started out, albeit by reference to the 1 year, paragraph 117, was by asking, well, is the evidence sufficient for me to make a rational decision? And that's exactly, that's exactly the right question to have asked. Is the evidence sufficient to make a rational decision? To which I say, on his analysis, the answer to that question is yes. It was sufficient for him to make a rational decision. And he spells out, whilst there are gaps in the evidence, he spells that out in the very careful way that he's analysed each of the components. And there's really, in my suspicion, only one area where there is a question mark over whether the evidence is sufficiently reliable to reach a rational decision. And that's the question of sale prices. To which I say, in the circumstances in which there are a large number of invoices, albeit that it's overall a small sample, and there is no evidence going another way that would lead a court to suggest that this can't be reliable, despite many opportunities for there to be evidence going another way, then unless the judge asks the question, well, is this evidence of sale of these sale prices unreliable or biased or unrepresentative? Unless he's doing that, then he does have a rational evidential basis for following through the conclusions that he made. And that leads to not departing from his calculation in Appendix 2, but to a conclusion that, well, on this evidence, there is sufficient evidence to rationally conclude that there were under-declarations of the or misappropriations of the levels that he had. There's only one point which...
Can I just ask, how does the judge factor in his 2009 calculation?
Well, what he does is he says, as a starting point...
No, I meant on your case. How does he factor it in?
On my case?
Yes. Is it a relevant
I don't think it's
conclusion?
relevant. I don't think it's relevant. It's not relevant. The reason it's not relevant is, yes, there is a snapshot that's been made of that year. And in that year, applying the approach that he has applied, it doesn't show an under-declaration. But that's not the case that we're looking at. The case we're looking at is, pleaded case is, well, what was the company's position overall over the entirety of its trading life? And the question there is the calculation that the judge has made over the entire 10 years, is that a calculation upon which one can rationally place reliance? What happens in 2009 is not significant. And I make that point in another way. Even if the judge had held that 2009 there were under-declarations in 2009, and let's even suppose that they were significant under-declarations in 2009, that wouldn't have been sufficient for the claimant to have succeeded in its case, because its case was, over the entire 10-year period, there were under-declarations done to purported a misappropriation of the company's monies. So 2009, yes, of course, was the way into this case, if I put it that way, how the exercise started out. But the purpose of this case is not to look at what happened in 2009, but what happened over the entire 10-year period.
Can I just push you a little bit further on that? So, as I understand it, your key point about this aspect of the case is to say, well, the methodology is the same. Look at Appendix 1 and Appendix 2. The methodology is the same. The only difference is the number of years. So the inputs into the calculation are identical. And therefore one arrives at this. Logically, there's two answers. First of all, the reason for the difference is that in 2009, the company truthfully reported its turnover, whereas in other years, it did not. That's one possibility. And as I understand your submissions, that's the logical answer you have to accept. The alternative, logically, is that actually the calculations can't be relied upon. Now, the judge's answer is answer 2. And I understand why you say that's wrong and why you say that the better answer is answer 1. But I think you have to go a little further and say not merely that the judge was wrong to give answer 2, but that it was impermissible. So how do you reach that hurdle?
It was impermissible to reach answer 2 because what the judge is tasked with doing is looking at the entirety of the company's trading life and applying the assumptions that he does, whether the outcome is that there were the under-declarations that he's identified. That involves within it, I think this is part, that involves within it an assessment of the reliability of the component parts. I can't get away from that. That's the fundamental point.
Yeah, and I understand perfectly well that you say the judge was able to make a finding on each of the component parts. And then, once he's made findings on each of the component parts, the rest of it is just arithmetic. So I get that.
Once he's made findings on each of the component parts, and he has concluded that they are reliable, or they're based on the defendant's evidence, or there is no evidence that counts against them, then it is inference for him to say, well, actually, the material of the evidence can't be reliable.
Well, yeah, but what I'm trying to explore is a slightly different question, because I get your argument on the component parts, and you say once he's made findings on each element, after that it's just arithmetic, and the result is a 12.2% variation. I understand your submission. You say not only that, but on each of the component parts, either he's accepting the defendant's case and the defendant's evidence, in which case how on earth can they challenge it, or it's reliable anyway because otherwise he couldn't have made a finding. I get all of that. And I understand you say to the extent he resorted to the burden of proof he shouldn't have done, because the logical answer then would have been to say, well, he can't make a finding. But actually he did. So I understand all of that. But you're still left at the end of the day with the conundrum that was being put to you earlier, which is that the end result of all of that is that you can't challenge the finding in relation to 2009, that there was no under-declaration, and yet you say the evidence shows that there was under-declaration across the period as a whole. And then one says, well, what's the logical explanation for that? And then there are the two alternatives. And that's what I'm troubled about at the moment.
So, where one gets to in an analysis of one particular year doesn't tell one very much about the analysis over the whole. And one could speculate, but it would be no more than speculation. It wouldn't be based on evidence. One could speculate as to why it might be that in 2009, on those calculations, there was not an under-declaration. One could speculate that throughout the 10-year period, there could be years in which there were under-declarations, or and some years that there were. But that would be speculation. That wouldn't be any evidence. So, maybe this doesn't answer your point, but one doesn't get in from looking at 2009 in isolation. It doesn't assist. It doesn't assist the process in answering the question which
yeah. So your answer to my question, I think, if I've understood correctly, is at the end of the day, the figures show what the figures show. Once it is accepted, as the judge apparently did, that the component parts, when added up together, show a variance of 12.2%, and that's the answer. In your submission, it's as simple as that.
But also, unless there's anything else, those are my submissions.
No, thank you very much. Yes.
I'll start, if I may, with ground one and deal with this in four parts. First of all...
Sorry, Mr. Leeper, before you carry on, I just realised Mr. Shaw didn't say anything about round four. Is that being pursued?
I'm so sorry. Faintly, I think it is. And it's only this. It has to be taken into account that Mr. Dalal was the director. As a fiduciary, he does owe a duty to explain its transactions and account for its transactions. And to the extent that his case, to a considerable extent, relies on an inadequacy of records to show the complete picture, that's not an argument that carries a lot of weight. And I don't think there's anything more I want to say.
Thank you. Yes.
Yes, it was thank you. I had assumed it had been advanced so faintly that I couldn't hear it. So, in dealing with ground one, I'll deal with this in four stages, if I may. First of all, a brief overview. Secondly, addressing the law, which encompasses, I think, grounds one and two. Thirdly, how the case was developed below, and just by way of précis, I don't accept a learned friend's characterisation of how the defendant advanced the case at trial. And fourth, some conclusions that I invite you to draw from that. So in relation to ground one, the single issue that this relates to as has been expounded by my learned friend, is the actual sales price. There are two parts to considering this ground in my submission. Firstly, what was the case before the judge? And secondly, did the judge exceed his powers by going beyond that case? As to the first, the issue before the judge was whether the appellant had demonstrated on the balance of probabilities that the company had understated its sales over a 10-year period. So that was the issue before the judge. And the appellant pursued its case all the way through trial by reference to a sales price derived from 5 invoices from 2009, and then sought to extrapolate from that figure. So the appellant's case was look at 2009 and extrapolate from it, which is why I find it surprising that his position before your lordships is that you don't get anything from looking at a single year. It doesn't take you anywhere. You have to look at the analysis over the full period, because that wasn't his case at trial. It's quite the reverse. And in looking at the 5 invoices in 2009, the judge rejected that case. He said that that evidence was too unreliable to base any conclusion on. Paragraph 170 of the judgment, at page 72. On that basis, the claim would have failed. So the claim as advanced by the appellant at trial would have failed. However, the judge permitted it, the appellant took advantage of it, seeks to do so today. There were alternative bases, canvas before the judge as to how you might fix on a price. One of those was based on a review of 182 invoices. That was not an analysis that had been pleaded by the appellant. It was one that hadn't been relied upon by the appellant at trial. And that's because that analysis was done by Moylan Jr. in the course of preparing closing. In relation to that analysis, the judge said at paragraph 172, a passage you've seen before at page 73, that it was not a very reliable guide. So, my learned friend keeps emphasising what the judge said about reliability. But in relation to this analysis, which is the foundation of the conclusion he invites to be drawn on this appeal, that the analysis of the 182 invoices is the most reliable source of information, but not a very reliable guide. It's the best evidence available.
Are you telling us that was not those were not relied on by the appellant before the judge? When you say alternatives were canvassed before the judge.
Alternatives were canvassed. I'll take you to one or two of them.
Okay.
What learned friend said, you can look at 5 invoices. Another thing you could do is look at the first 10 of the 182 invoices. So he did an analysis, and I'll take it to you shortly, but he did an analysis of the first 10 of the 182 invoices.
But sorry,
and that was annexed to his closing.
So the appellant's case below was never, you can rely on the 180, the product of the analysis undertaken in respect of the 182
That wasn't
invoices.
its positive case. So the positive case was, look at the 5 invoices. There are other sources of information. So here's what the liquidators say. Here's my analysis in, this is my learned friend, here's my analysis in closing of the first 10 invoices of the 182. That was an annex to his submissions. And then Moylan Jr. put forward an analysis of all 182 that were available, and it came up with a different figure. And the essence of the defendant's case was, you've got all of these figures. One of them is these 182 invoices. But what that shows is you can't rely on the evidence because it doesn't provide you with any reliable outcome. That was the essence of the defendant's case. Not, here's an analysis of the 182 invoices. they produce this figure and it must be right. It was, here's another analysis. It comes up with yet another figure. How can you be confident about the outcome of any of this? What the appellant now says is that because the court fed in the 182 sales price figure into its Appendix 2 and produced an outcome by a methodology, that the court was bound to take the further step of extrapolating that price over the full life of the company, because effectively there was no reason
price
not to.
produced by Ms. Fisher's analysis was lower than anything previously suggested. And there was no evidence before the court to suggest still lower figures. So can I be clear? Do you say it was not open to the judge to make the findings that he did?
Well,
Because there's no respondent
with
notice.
respect, your lordship's made that characterisation a number of times. I don't accept that the judge found as a fact that the relevant price was the price that was produced by the 182 invoices.
Well, in 172 he says it's the best evidence available.
Yes.
And then in 173 he sets out consistent price for whole chickens 175 per kilo, and he uses that figure. 174 average price for parts. The analysis is 2.37, and he adopts that.
Yes, well, he says, I propose to adopt it, but what's he adopting it for? What purpose? To feed into the methodology in Appendix 1, which shows if that methodology is adopted, that there was no understatement in 2009, and then he feeds it into the same methodology, but over the 10-year period, to produce another outcome. But what I say that the court doesn't conclude is that the product of feeding those figures into Appendix 2 is the outcome. It's the outcome of a methodology which the judge is applying, and which at paragraph 117 he describes as being a very rough estimate. So what he's trying to do is, look, here's the evidence I've got. I'm going to try my very best to produce some figures. But then at the ultimate part, he's got to decide whether he can rely upon that methodology and those figures. And his conclusion at that stage is that he can't, and therefore he cannot conclude that there's an understatement of sales. What he doesn't say in the passage that your lordship's saying to, at least in my submission, what he doesn't say at that point is that he is finding as a fact that there was an understatement of sales in accordance with Appendix 2.
To be sure, because at these paragraphs he's just looking at the components.
Yes.
And can I ask you this question? Any evidence that you're able to point to of lower prices than 1.75 for whole chickens and 2.375 as an average for chicken parts? Any evidence at all of lower prices?
There were various sources of evidence as to what an average price might be, and the judge having to decide, can I rely upon that price? It looks at the fact that if you cut it in different ways, you come up with various different prices, and he's entitled to conclude that given, for example, the sample size and so forth, it's not reliable. And as your lordship yourself put to my learned friend, it was never said to Mr. Dalal in cross-examination, well, these must be representative figures, and that's because the appellant, and indeed the defendant, hadn't hit upon that analysis as being representative or not representative.
I take that point, and we'll come back to that.
Yeah.
But to be clear, the answer to my question, I take it, therefore, is no. There is no evidence of lower prices. Now, the consequences of that downstream is a different
Absolutely.
matter.
No, so far as I know, and I'll check over the short adjournment, there were all sorts of prices, but I'm not sure there was anything of a low.
Well, all the other ones we've been shown so far are higher.
Yes.
There's just a reference in the closing submissions in paragraph 23 on page 212 to, I don't know what that's a reference to.
Sorry, is that in the
Supplemental bundle. Paragraph 23, page 212.
Oh, I'm sorry, you're right. Paragraph 23, the second defendant had suggested that the cost could be as low as 80p a kilo. So that, I assume, was part of the evidence. I'll get chapter and verse on that over the short term.
So that would suggest there was evidence of lower prices.
Yeah.
I don't know, page 213, I don't know what page 213 is a reference to.
It must be to the trial bundle.
It must be trial bundle, or were there transcripts, or?
No.
No.
Yeah, sorry, there were daily transcripts, but I think that must be a reference to the trial bundle, because it would have
To be clear, actually, that was a figure that appeared in Sajid Dalal's witness statement in opposition to set aside the default judgment that he obtained. It didn't form part of any of the witness statements for trial.
I just said there's a reference to it in the submission, so I don't know. Anyway, thank you.
well, I'm grateful.
Yeah.
So it seems not. It seems that there wasn't
Certainly there wasn't any documentary evidence,
potent evidence.
no invoices or anything with lower prices.
There were invoices. There were invoices when you take the average price. There are obviously lots of invoices which have much lower figures than that.
Well, not for the whole chickens, for the parts. Of course, obviously
Yes,
they move around.
Exactly right. So I think that the £1.75 was applied consistently. There's one exception because it wasn't in the BEE. The business exercise took a price for chickens, whether whole or part. So it was only later on that there was this division that the trial judge thought was material, that there must be a difference in price as to whether you sell it whole or in parts. But the case as advanced by the appellant and through the business evaluation exercise was that there was a price for the sale of chickens, whether whole or in part. Can I, if I may, and I'll turn to the detail in a moment, can I just deal with what my learned friend says about the law? In his skeleton argument on page 23, he summarises a number of cases, and then at the very foot of the page says, the principles that may be derived from those cases and the authorities referred to in them.
Sorry, which paragraph?
So it's paragraph 33.
Thank you.
And then the principles he derives are at the top of page 24. I should say I don't disagree with any of these, but I do propose adding to them. So first of all, the parties' statements of case play a crucial role in civil litigation, which ought not to be diminished. It's important for a party who wants to run a particular case to plead it. Judge ought not to determine a case on a basis that wasn't pleaded or canvassed before him. If a judge makes findings on a basis that was not contended for, he crosses the line between adversarial and inquisitorial systems. Now, just looking at that fourth one, that is not saying if you've got two contested theories, you can't find a middle ground. So as my Lord of Moylan suggested, if you've got a PI case and you've got one person saying it was all their fault, the other saying it's all their fault, you can find a balanced 60-40 of liability. What you can't say is, well, actually, I think it was the man on the motorbike who was coming in from the right, because that's not what either party is contending. That is a new theory which isn't part of any party's place. But if you're trying to, if the issue is who is liable as between the claimant and defendant, you could either find it's 100% one, 100% the other, or anything in between, whether or not the parties are saying that there is a mix of liability. I have four further propositions, which I'll take you to the authorities to, but to save your pen, I've reduced them, if I may, to a sheet which adds to my learned friend. So you'll see that propositions 1 to 4 are those of learned friend. I seek to add to them as follows. So 5, the pleadings are important so the parties can know the issues that need to be addressed in evidence and submissions. So the court can know what issues it's being asked to decide. Sorry for the time. But a trial judge can always permit a departure from a pleaded case where it's just to do so, and where it might cause prejudice, the other party is entitled to assist on a formal application to amend. And I've taken that from the case of Satyam at paragraph 35, and you have the page reference there. Proposition 6, the judge is not bound to make a finding one way or the other, but has a third alternative of saying that the party on whom the burden of proof lies has failed to discharge that burden. That is from the Poppy M, which is quoted in paragraph 32 of the Nulty case. 7, in a case based on circumstantial evidence, at the end of any systematic analysis, the court has to stand back and ask itself the ultimate question, whether it is satisfied that the suggested explanation is more likely than not to be true. And lastly, that's also from Nulty, and lastly, a determination of past fact involves an overall assessment of the evidence.
Can you assist me as to the relevance of Proposition 7 to our case? This is not a case based on circumstantial evidence, is it?
Well, I would suggest that it is, or it's akin to that. So what you don't have is any direct evidence that there is an overstatement of the accounts, and no direct evidence that there was any extraction of monies by the defendants, or at least, if we focus on my kind, the respondent to the appeal. So what the appellant is saying is, I am going to reconstruct figures based on what we know about the number of chickens that went through the process and what the likely costs would be. And from that evidence, so it's a theory, a methodology, you can conclude that there was an understatement of sales and therefore infer that there was some sort of wrongdoing on the part of the defendants, whether it's a misappropriation of the money, redirection to family members, or some sort of breach of fiduciary duty. So I would suggest that it is a case of circumstantial evidence because there is no direct evidence of abstraction and there's no direct evidence of an understatement. It is all based on a reconstruction from which the court is invited to draw conclusions. It is a theory and a methodology. And the methodology that was advanced in the appellant's pleading was based on a BEE, which produces a vast figure of understatement of accounts, but then says, well, but we're going to accept that it's only 20% of that figure. All speculation and theory. So I'll come on to explain how Proposition 7 feeds into this case, but I do say that it does, that there is, and that's exactly the point that I was seeking to address with Your Lordship, which is the judge isn't saying, even when he's dealing with the price level, he's not saying, I conclude that this must be the price that is put in. He's saying, I'm going to try it, but at the end of it, I have to stand back and test the evidence in the round to determine whether, on the balance of probabilities, I am satisfied that the accounts over this period were understated in that way. May I turn then to how the case developed? Now, my learned friend has recognised that this isn't strictly a pleading point, but if I may, I'll just quickly take you back to the pleadings so that I explain the background to how we get to trial and what the claimant says it can prove from the materials that it has. So, starting with the particulars of claim, in the core bundle of page 92, and I know Your Lordships have seen it, I'll take it quickly. So paragraph 10 HMRC undertakes some assessments which produce some figures. 11, the basis of the assessments, which were raised following an investigation by HMRC, is set out in documents produced by HMRC without specifically identifying what they are, copies of which have been provided to the defendants. And then 12, a summary of how the assessment is undertaken. And 12.3, HMRC extrapolates from the slaughter figures from September 2009 to the whole period of the company's trading to calculate the completed sales of slaughtered birds as against the, to produce a sale value. And then that is cut by 20%, 12.5. And so there's a figure of 7.1 million at least of understated sales. And then just to see how that feeds into the claim itself, 15, in the premises set out above, so based on that analysis, that theoretical analysis, the defendants caused or allowed the company artificially to suppress its apparent sales, which had the effect of creating a substantial cash surplus, that the defendant caused or allowed to be misapplied because it wasn't accounted for the company or applied to its benefit. And a couple of other, just one more reference. So at page 94, paragraph 20, in the premises it's averred that the additional sales receipts were paid in cash to the defendants for their joint benefit, or 21, or were misappropriated and or monies hadn't received by the defendants. Then into the response to that in the defence, page 108, so this is addressing paragraphs 10 to 12. The accuracy of HMRC's assessments is denied in general. And then there are a number of particular issues which are taken up. One of them, B1, HMRC figures were based on a retail model. That wasn't sustained, but what that went to was the pricing. So the pricing in method 1 at least was challenged. And the overall sales are denied in paragraph 11C over the page. It also sets out the AMS approach. And at 12B, you'll see that AMS investigated the correct level of turnover by sampling quarterly sales and purchase invoices in parallel with an analysis of the average cost per kilo for each bird slaughtered. So again, price is clearly at large.
Well, you say it's at large, but would you not accept that reliance is there being placed on the AMS report, and in particular, the average cost per kilo in that report?
What is being said here is simply that there is another analysis. So no reference is made in the particulars of claim to the contents of another report. And that is saying there is an alternative methodology at large already, even at that stage, and it produces different figures. So your submission is that we read this as a plea by your client that not only is there this AMS report which contains different figures, but also an assertion that the different figures in the AMS report are wrong? No, because what it says in paragraph 12 is that the particulars of claim have ignored an alternative methodology. So they're saying that there is a method, there is the methodology.
So what does the word correct mean in paragraph 12b?
That is what it says, that is what AMS were looking into. And it produces a different figure.
So how does the reader know from this document that what's said in the AMS report Mr. Dalal is going to contend is wrong, particularly with reference to average cost per kilogram?
Well, there's the general denial, there's a denial in paragraph 20 that the additional sales receipts are accurate or that they were paid to the defendant. And one final point, if I may, but for this we have to go to the reply, which is in the supplementary bundle at page 2, I think. So paragraph 3, it is page 2, paragraph 3. It's denied that in calculating the assessments, HMRC employed underlying methods, estimations and assumptions that were fundamentally flawed. They were based on an extrapolation from 2009. 3.3, two distinct methodologies, one based on the average wholesale price, second based on the company's own average sale price. So they're advancing two separate bases for calculating a sales price figure. And then at 5...
Well, if we look at paragraph 4, first of all, it's denied that any reliance may be placed on the AMS report. Alternatively, the AMS report is flawed. Now, I appreciate that they're contesting AMS there, but does that not show that they understood you to be relying upon the AMS report?
Well, I don't accept that, because if you look at paragraph 5, in addition to the matters set out at 3 and 4, based upon the FSA's recording of the company's slaughtered chickens, the liquidator of the company has calculated the total sales on the assumptions of an average price of £2.75.
To be sure. So the case that's being put forward by the claimant is you should adopt the methodology adopted by HMRC, the business exercise, economics exercise, and they're even going so far here as to rely upon method 1, whereas subsequently they retreated to method 2. So clearly they are saying, follow the HMRC method, don't follow AMS.
Yeah.
But
there's
the question I'm putting to you is, where on the pleading case thus far do we see the AMS figures being challenged? Because what we see is, but by your clients, they're challenged by the claimant, but on the basis of AMS is too low.
Yes.
It should be higher figures, and in particular a higher price.
Yes, but they also, at 5, they're making clear in what is said in the reply in paragraph 5, that a recognition that the issue of price is at large. And what the defence says is it denies that reliance can be
I don't
placed.
understand that, because there's a floor and a ceiling. So
I
the
don't-
ceiling...
With respect, I don't accept that that's right. I understand the point, but I don't accept that it's right, because what the defence says is we don't accept that the assessments are right. There are a number of reasons why, including the following. But you are put to proof about price. And that is the issue that was before the judge. My learned friend has acknowledged that that is right. My learned friend has acknowledged that he took advantage of the variability that there was in the pricing and had to do so because the case that he was advancing based on the 5 invoices was so flawed that the judge wouldn't place any reliance upon it at all. And so the whole issue of price became at large. My learned friend's real...
Can I ask you this question?
Yeah.
Would you submit it was open to the judge to say that the correct price was 5p per kilo?
Not on the evidence that was adduced, no.
So the price wasn't totally at large. There were bounds.
Well, no. Well, there are bounds, but they're not placed there by the pleading. They're placed there by the evidence and the assessment of the evidence.
At the moment, you're just dealing with the pleading
Exactly
aspect,
right.
and you're saying, as a matter of price was at issue.
Yes, and I don't think my learned friend disagrees with that.
Well, certainly there was. I mean, we haven't seen the transcript, but I'm sure there was a lot of investigation of price during the course of the hearing, and if price was not at issue, there wouldn't have been no investigation of the issue of price.
And the reason for that is that the appellant faced a difficulty that the judge was not going to be satisfied by fixing a price, as HMRC had done, based on 5 invoices. Because that's just, to look at 5 invoices over the course of 10 years of trading cannot possibly provide you with any reliable basis for concluding on price. And so the appellant was happy for there to be explorations of other ways of finding a price. And the defendant's position was, there is not a safe methodology here. There is not a safe way of fixing on a price. So that's the sort of background to it. Then just looking at what the claimant's initial case was, it was that the prices within the BEE were representative. But there were, of course, within it two prices. You've seen the underlying document, but it's also recorded in the judgment, page 51 of the core bundle.
Sorry, 51.
51, yes. So, paragraph 30, so there are two calculations made in the business economics exercise. Both assume an average weight of 2 kilos. The first is based on a price per kilo of chicken meat of £2.75. And the second used a price per kilo of chicken meat of £2.62. And that is the one that was derived from the 5 invoices referred to above. That's a cross-reference to paragraph 17 for your note. And that produces a different conclusion. In relation to method 1, that was not pursued by the appellant, but only at the point of closing. So the evidence didn't make good that that was a figure that could be relied upon. And so by the point of closing the trial, learned friend did not pursue the figure in method 1.
So when you say the claimant's case at the outset of the hearing,
Yes.
was method 1, or because I thought you said earlier on that his case was based on the 5 invoices, but was that also just referring to how it has developed during the course of the hearing?
Exactly, how it is. But at the start of the
hearing. So at the beginning of the hearing, it was either method 1 or method 2. By the end of the hearing, it was solely method 2.
Because the appellant decided not to pursue the price within method 1. So that's recorded in paragraph 169 on page 72. So in closing submissions, Mr. Shaw correctly disclaimed any reliance on method 1.
Yes.
Then, as to method 2 at paragraph 170, the judge says at the top of page 73, I do not think that a sample of only 0.25% of the sales in a year, that 1 year, can be regarded as a reliable method for establishing the average selling price. You were taken to Mr. Dalal's witness statement. So this is back, I'm afraid, in the supplementary bundle. You were taken to paragraph 16 of that.
Sorry.
Page 45.
Thank you.
So you were taken to the first 5 lines of paragraph 16. There were other observations. So paragraph 17, Mr. Dalal's evidence was that the company's customers were also very demanding. The company mostly sold to small shops and takeaways who would buy at the cheapest possible price so that they could make a maximum profit, but at the same time demanding very high quality. And 18, HMRC's figures were also based on sales to retail, that the company was a wholesaler in a very competitive market to sale prices to small shops and takeaways would be lower than the industry average. Customers were also very demanding and would request discounts because, for example, of quality issue and the HMRC figures do not give adequate adjustment. So Mr. Dalal at that point is addressing the case that has been that was being advanced by the claimants at that point, which was method 1 or method 2. And he's saying, actually, you can't, my position is you can't rely upon HMRC's assessments because we have these pressures of pricing upon us. May I then take you to the way in which the position had reached by the point of closing. First of all, at page, in the same bundle, the supplementary bundle, page 188. So this is in...
Sorry, 188.
188.
Thank you. Yes.
So this is in the appellant's closing submissions, dealing with prices, difference in sale prices between whole birds and parts. In the BE analysis of invoices, whole birds were sold for £1.80, accounted for approximately a third. The average price of chicken parts was £2.51. Very similar prices appear in the sales ledgers of the company's sales to its customer, Jourdan Cash and Carry in 2011, a trial bundle reference. A sample analysis of 10 of those invoices is attached. That shows uniform sales of whole chickens at £1.75 and average sales of chicken parts of £2.69. So that's what I was referring to earlier. That's Malone & Friends' analysis of the first 10 of the 282 invoices.
182.
182. I'm very grateful. Invoices that there were. The analysis is in the bundle, but there was an updated version which hasn't made its way into the bundle. And so it's only partial, but I've seen the updated version and it does produce those figures. So an analysis of 10 of those invoices. And then lastly, whilst it was Mr. Dalal's evidence that prices would fluctuate, the sample analyses of actual prices of invoices seem to show relative consistency. An average price of parts would be £2.60 per kilo. Come back to the point of consistency in a moment. Then, if I may, page 209 in the same bundle. These are Mr. Dalal's written closing submissions, and at paragraph 3, Malone Jr. wrote this: the true method calculation is more complex than HMRC suggests. And she puts forward some 8 stages, and stage 6 is an average price for the produce is then to be applied. And then at page 212, stage 6, the £2.75 per kilo can simply be rejected as unevidenced, and indeed it was. £2.62 per kilo is based off merely 5 invoices over a short period of time. Where so few invoices are considered, the variance is considerably greater. And then further reference to the evidence, and your Lordship's seen the reference to a suggestion from D2. And then at page 214, paragraphs 37 and 38, there's evidence of the company changing over time. And the presumption, that is presumption continuity, thus cannot safely apply, especially with such a small and poor sample size. There are simply no general rules that such a presumption is generally applicable. This simply cannot be extrapolated in the manner suggested. In particular, A, the sample size is so poor, there is significant danger in seeking to extrapolate that across 10 years of business. The margins of error would be even greater.
Presumably that's in support of the submission of paragraph 21 about the 5 invoices.
Yes, but let me, if I may, take it to the last stage, and my last reference before the adjournment, if you'll permit me. page 333.
Sorry, before you get to that, just can you help me? I haven't found in this document any reference to the analysis of the 182 invoices. Did that come in separately?
Yes, you'll see that it comes after, it came slightly afterwards. It's in the bundle at page 221, but without commentary. And I'll take you to a little bit of the commentary. That was my next reference.
Sorry, can you give me the page again?
333.
Thank you.
I'm afraid it's in a transcript, so not the easiest thing to read. I can blow mine up on screen. So
Yes. Which
it's page
box?
83, which is the top right.
Top right. Thank you.
Would it help me to read it, or are you happy?
I
with
think
it?
it might help you read it.
So, Ms. Fisher says at line 3, I provided the court with 2 spreadsheets, and the first one I've entitled...
Wait a minute. Top 333, top right.
So, yes,
Yes,
line...
I provided the court's funded. Thank you.
and the first one I've entitled Dalal spreadsheet, and that's the document of 221. It is the one which includes various permutations and calculations that the court might draw. Now, I ought to point out from the outset that it is not my submission that the court ought to be looking at this and saying, well, that's the calculation that I agree with, and therefore that is that which I'm going to substitute for the BEE of the claimant. My primary submission, very simply, my lord, is that the claimant cannot prove its case. My primary submission is that there is insufficient from the claimant's side to prove that there are any under declarations, bearing in mind that when one is dealing with cases of this nature, there has to be some margin of error, and whatever calculations ultimately one might look towards, one cannot say, I say within this case, that they're out with the broad range of that margin which ought to be allowed in a case of this nature. So the primary position of Mr. Dalal was, here is a spreadsheet. I'm not saying you should adopt it. I'm saying that it provides a different set of figures, that there are bound to be margins of error, and the claimant can't prove its case.
Did the claimant appellant ever actually invite the judge to adopt that spreadsheet?
Let me check on that over the German.
So we'll stop there and start again at 2 o'clock.
Thank you very much.